Do you know that temporary residents in Canada are allowed to have the intention to apply for permanent immigration? This is known as dual intent, which refers to the situation where a foreign national has either applied for, or may apply for, permanent residence in Canada, but has also applied for a temporary stay in Canada as a visitor, student, or worker. For detailed information, watch this video till the end, and yes, like and share the video, and don't forget to subscribe to our channel.
Warm welcome from Brain Drain Consultants to our immigration information and news channel, A2Z Immigration Updates.
On April 5th, Immigration, Refugees and Citizenship Canada, IRCC, updated its program instructions for cases of dual intent. The update acknowledges that having two intentions, initially for temporary residence and eventually for permanent residence, is legitimate and complementary. This legitimacy should be used when applying subsection 22(2) of the Immigration and Refugee Protection Act, IRPA, to the decision-making process. Subsection 22(2) states that a foreign national's intention to become a permanent resident does not preclude them from becoming a temporary resident as long as the IRCC officer is satisfied that they will leave Canada at the end of their authorized stay. The updated instructions also include a section on temporary resident to permanent resident programs, which reminds IRCC officers that Canada promotes these programs to foreign nationals, and that Canadian work experience is fundamental to successful settlement. Facilitative pathways that attract temporary residents with essential skills or experience, such as the Caregiver Pilot, Canadian Experience Class, and Agri-Food Pilot, have been relied upon as routes to permanent residence. Other programs give extra points for applicants whose work or study experience is in Canada. When considering study permit applications, officers need to take into consideration that Canada actively promotes study-work permanent residence pathways to prospective students, and that these students are encouraged to indicate their intention to immigrate to Canada permanently. To approve a temporary resident application, the officer must examine the individual circumstances of the applicant and assess whether they have a genuine intention to leave Canada at the end of their period of authorized stay. Factors such as means of support, obligations and ties to the home country, purpose and context of the stay, credibility of documents and information submitted, and past compliance with requirements of the IRPA and the IRPR that are applicable to temporary residents, visitors, students, and workers, as well as information available in biographic and biometric information sharing, may be considered. The updated instructions state that the assessment of an application where an applicant has dual intent should be the same as the assessment of any other temporary residence application. Each applicant should receive a fair and individual assessment based on the entire context of the application, and the applicant has the right to a fair and impartial decision-maker. The officer must avoid the possibility or perception of bias, such as assuming that an applicant with an open or prospective permanent residence application will automatically desire to stay in Canada beyond their authorized stay.
We hope you appreciate our efforts to provide important and accurate immigration information. Please share your feedback and suggestions in the comments section. Please like, share, and subscribe to our channel to show your support, and yes, don't forget to press the bell icon. Thank you for your valuable time, and we hope to see you again soon with another video. If you need any further assistance or want to discuss anything related to your immigration dreams, then you can book an expert consultation session with our team of registered migration consultants.